Welcome, everyone. My name is Amy Prenda, and I'm the CLE Director here at the Nebraska State Bar Association, and we're going to go ahead and get started on today's program, which is A New Age, How Social Media Impacts Ethical Conduct. And your speaker today is Diana Vogt of Sherrets Bruno Vogt in Omaha, and she has over 25 years of civil litigation experience with an emphasis on federal court practice. She also has experience litigating employment law, discrimination, and civil rights on behalf of both plaintiffs and defendants. So please welcome Diana.
Good afternoon. That was a very nice introduction. Thank you, Amy. A lot of the things you're going to hear today that attorneys and judges have done with social media, you're going to say, who would ever do that? But think back to the last time something came out of your mouth that you didn't want for it to come out of your mouth. Well, social media is like that, only it never goes away. And one of the first things we're going to be talking about is several states have passed requirements for technological competence, and in fact have required or believe that it's an ethical requirement for attorneys to actually be familiar with Facebook. So if you're not already on Facebook, you need to at least be familiar enough with it to advise your clients. And now I'm going to start with a quote from Facebook. Love as if you've never been hurt, dance as if no one is watching, and draft every email as if it's going to be an exhibit. And some of the things that we're going to see might be contradictory because different states have taken different approaches. So my advice now, and I'll repeat at the end, is if you're ever in doubt, don't do it. And never, ever, ever post or send an email or tweet when you're angry. Take a day, think about it, and you might change your mind. It's just for your entertainment. And that's the trouble with social media, is often there is not room for the disclaimer. Okay, the rule of competence. This is the one that at least 28 states have found that in order to be competent, you have to be able to advise your clients about their use of Facebook. And if anybody thinks, well, you know, Facebook seems like kind of a pain. My 87-year-old mother is on Facebook. So it's more of a mental block than actually anything. Get one of your nieces, nephews, whatever, to explain it to you. They'll know. And diligence. Diligence requires the lawyer to act with reasonable diligence and promptness always. And New York Bar Association has gone so far to indicate that an attorney's obligation to represent clients competently could, in some circumstances, create an obligation to advise clients within legal and ethical requirements concerning what steps to take to mitigate any adverse effects on the client's position. And New York has formally reprimanded and sanctioned an attorney for failing to investigate a client's Facebook activity. Now, what can you do? Well, just assume, first of all, that your client is on Facebook. And some people can't go for a day without having to bring everybody in on what they're doing. But some of the things you can do is you can tell them what things to remove. If there's no litigation or the litigation is not reasonably anticipated, you have no possible ramifications from telling them to remove things from their account. However, tell them to keep some record of it and not to destroy it completely, because you don't want to be in that position later on. Now, what things should or should not be posted? Obviously, truthful information is okay. You may advise your clients to use the highest possible privacy settings. And more on that as a little aside, if anybody has an Android phone, a system update to that last week changed my privacy settings on Facebook. So if you have an Android and you use Facebook on it, check your privacy settings, because they may now, mine had been reset to public. And I didn't notice until I started getting comments from people I'd never heard of. So check that regularly because your phone can change it itself. Now with discovery, you do have a duty to maintain evidence, and especially if discovery requests are already outstanding. And remember to remind your clients that the opposing party or counsel is going to obtain this information. It's public. And you need to explain to them how this information from the social media might be used in court. So, for example, somebody came to me and they weren't in a suit yet. And it's actually a friend of my daughter's because I don't do family law, and was afraid that her boyfriend was going to start seeking custody of the children, even though he'd shown no interest for years. I went to her Facebook page, and her cover photo was of her in a bar drinking. So I suggested that that not be her public profile page. Okay, back to some more advice. I think this would be horrible, but you can review material that your client wants to post. And if they come to you and say, you know, is this okay? Take a look at it because there can be ramifications. Now, you may not advise the client to post fake, misleading, or defamatory information. And also be careful that your client's Facebook or other postings don't contain information that would show that their claims are maybe false. And caution clients about posts that might violate a court order or a contractual agreement. Now, before we go on, when it comes to advising them about removing things, I want to tell you a cautionary tale. In a case that is cited there at the bottom of the page, the attorney told his client to remove things from Facebook, and they didn't produce either paper copies or a trail or preserve anything from it. And he was under a discovery request already at the time he gave the client this advice. They found that he had violated the duty of candor to the tribunal and fairness to opposing counsel. And the Virginia Bar Association suspended him for 5 years, fined the attorney $542,000, and the client $180,000. So, and I happened to read this case the day after I told my daughter's friend to remove her Facebook post. But we weren't in litigation. Nothing was happening yet. I was under no discovery obligation. So I breathed a little easier, but there can be really big ramifications. And then in a case called Gatto versus United Airlines, a plaintiff was granted an adverse inference instruction after there was material that was not produced that had been on social media. So once it's there, it's going to be there. So tell your clients, don't post anything that can't be exhibit number 1 in this case. Okay. Now in a recent case in Texas, and this is another one where you want to keep your clients out of trouble before they get into it rather than later. A couple was dissatisfied with having to pay a final $100 fee to a wedding photographer. So they started a social media campaign talking about how they had to pay another $100 just to get their album. She was holding them hostage, blah, blah, blah. Media, the regular media picked up on her social media. They interviewed them. They went on TV. They made all the same allegations. The photographer lost her business, sued them, and just within the last 60 days, the jury verdict came in $1 million for the loss of her business from something that just started from just a little complaint on Facebook. Oh, this is a good one. You also need to make sure that anything posted doesn't violate a court order. Mama and Papa Snay won the case against Gulliver. Gulliver is now officially paying for my vacation to Europe this summer. Suck it. This was in violation of a confidentiality provision in a confidential settlement, and the plaintiff had to forfeit the entire $80,000 judgment. So it's important. And then I kind of like this quote. Many social media users are oblivious or indifferent to what may happen when their travel logs, photographs, streams of consciousness, rants, and all manner of postings find their way into the hands of family, potential employers, school admission officers, romantic contacts, and others. One of the biggest examples of this is people calling in and saying they're sick, and then they do something else and post pictures on Facebook. Well, if your boss or your client's boss sees a picture of you on Facebook, say at a Halloween costume party, they're probably not going to believe that you're sick. Now, the scope of representation. 28 states have now found that you have a duty to be technologically competent. It does not appear that Nebraska is one of them, but I forgot to email Mark Weber to check for sure. But other states are just putting it under the general duty of diligence and competence that you know how to use Facebook. But there's also the question of how much information can you give without creating an unintended attorney-client relationship. Now, communication on social media will sometimes be sufficient to create an attorney-client relationship. If it is established, then all of the duties that you would normally owe to any other client attach. Now, if you want to prevent this by use of a disclaimer, the disclaimer has to be prominent. There are a lot more issues with this, however. Several years ago, it was the American Bar Association's position that an attorney should check their email often, lest they miss an unsolicited question or potential engagement. Now the pendulum is swinging more towards, if you don't answer it, then you couldn't possibly have established a relationship. But if you get a request on the internet and they can get your email from the Bar Association, from a lot of sources, so that they don't have to go through your firm website, which probably does have a disclaimer about creating an attorney-client relationship. And if they email you directly and you don't respond, and there's something in there that indicates there's a possible time pressure, at least the ABA several years ago thought that that might create a duty on the attorney to have at least advised them about the urgency of the situation. But some of the things that you have to be careful about is, I'm sure a lot of you have had clients who come in, and at the beginning of the engagement, the facts are one way, and then you go to discovery. So you always run the risk, if you give a substantive answer in response to an email inquiry, that you're giving advice based on facts that don't really apply. So be very, very cautious there. The test is usually whether a reasonable person would believe that an attorney-client relationship was created. Unfortunately, as we know, many clients are not reasonable people. So it's better to just avoid being in that situation than have to defend yourself. The ABA has also suggested that a perfectly good response is that the individual should call, come in, provide more information, because you're always in danger if you give a substantive response without really knowing what all the facts are. Now, most firms on websites contain prominent disclaimers, and one of the things that we do is our firm just has a law account, and everything is supposed to go through that account so that it's screened by somebody who then sends it to the attorneys. The attorneys are then supposed to respond. They generally just go to 4 of us, and we respond whether or not we're interested. And then we send a decline letter. Even if all we have is their email, we just send a simple, decline letter saying we're not in the position to take cases of this type at this time, or something like that. That way, we know nobody can ever come back and say, well, we were waiting on you to tell us this. And if it does look like a case, then somebody will call them. We're going to talk about this more in a little while, but a lot of scams are now being created by people trolling to try and act like a client to get you to represent them, so that they can either hack your system and use ransomware, or the other scam is they tell you that there's this big contract and they want you to deposit this large check in your trust account and then forward them the difference. One imaginary client actually went so far once as to send me a check for like $3 million or something. Obviously, we knew it was not real because the person never called. Their only contact was email. There were always excuses. We told them not to send the check, but be on the lookout for that. And communications. You'd think that social media would make things easier to fulfill your obligation to keep the client informed. You must keep your client adequately informed about his or her case. Emails make it really, really easy to just send something off without providing any substance in that response. And just in the last 30 to 60 days, a Nebraska attorney was disciplined for using email to almost exclusively talk to his client and to just basically blow him off. Now, the attorney was also not properly handling the matter. He wasn't paying attention to it. But it's very easy if you have a high-maintenance client to see that you've got an email from them and think, okay, well, as soon as I finish this brief letter, whatever, fill in the blank, I'll go back and answer them. And you don't. It's also one of the things that we do is anything that's really important, we put it in a letter. And we attach the letter to the email, and then we also send it snail mail. For example, confirming permission to accept the settlement offer, or confirming anything else that is very critical that you want an absolute record of. You can also use read receipts. And then save the read receipts. And that will let you know if your client actually read the email. Really, really discourage yourself from using reply all. I've only messed up with it once. Unfortunately, I was talking about another attorney and included her on the email. So it was, we had been trying to engage local counsel in Arizona, and this one attorney said that she would do it and then decided she didn't want to do it, and that's what I was remarking on. But fortunately, it wasn't hugely horrible remark. Do not use BCCs on an email. Like if you send an email to opposing counsel and you want your client to know about it, do not use the BCC function of the email. If opposing counsel hits reply all, then opposing counsel is going to be sending something directly to your client, or vice versa. You are not to be sending things directly to your opposing counsel's client unless you have prior permission. So accidentally sending them something through use of BCC, or just CCing them. I had an attorney on the other side of the case not too long ago who regularly CC'd my client. And he said, well, you know, we got an email once that had his email on it, so I thought it was fine. Well, it's not fine. Courts that have looked at that and disciplinary committees have said that is improper contact with a represented party. And if you receive an email that you know was not meant for you, you should respond and say, I don't think this was meant for me. I haven't read it. I'm going to delete it. Just yesterday, I received an email on the Nebraska probate real estate listserv that was a private communication from a case. The attorney's name began, the receiving attorney's name began with RE. And so autocomplete sent it to the whole listserv. Then the attorney tried to recall it, but didn't do it in time. So then every time somebody else on the system deleted it, we got the notice that somebody had tried to recall this email. But, you know, there were many responses saying Um, we deleted this. We don't think it was meant to us. And then the attorney followed up. So if you're not checking your emails closely, if you don't look at what goes into that address bar, you might want to turn off autocomplete. You should also think twice about communicating with your attorney or with your client via text messages. Text messages, although they're supposed to be backed up in the cloud, your phone may not be set to back them up in the cloud. You have to enable that. Or something may happen that they can be destroyed. The best rule is just don't do it. Plus, it's kind of annoying if they're texting you all the time. But if you do use text to communicate with your client, and a text contains something important that you're going to do or you're not going to do or something like that, forward the text to your email and then save it from there, because it can be a real nightmare if you're going back months and months and months and months and trying to find like a one-line text. It's just better to maintain it in a form that's easier to find. Our engagement letters actually say that the clients aren't supposed to communicate with us by text. Unfortunately, one of our attorneys has apparently not read that. So we have at least gotten to the point where he will email things into the main law account, and then they can be saved, so we have a record of important things in text messages. It's also going to be easier to get a letter or an email into evidence than it is going to be a text message. Now, I've seen advertisements for a lot of CLEs on how you admit text messages, but I think it was about a year and a half ago or 2 years ago, I was in a trial in federal court with a judge from out of state, and she was an excellent, excellent judge. But we had a text message that we wanted to get into evidence, and she just said, I don't know how to do that, so I'm just going to say no. Fortunately, it was not really important, but you don't know if the judge is going to believe you when you say, no, judge, this is what we have to do to get a text message into evidence. They can just say no. Now, confidentiality in communications. The ABA opinion from quite a while ago that said it's not unethical to scrub a document of metadata is kind of dated. And they also said at that time it was not unethical to search metadata in received documents. But the New York County Lawyers Association has found it is unethical to search received documents for metadata. And California has a rule that requires it to be scrubbed before you pass it off to somebody else in case there's metadata. I encourage our clerks and associates, because none of us old guys do this, to not use the comment feature in Word. Because every now and then, even though you think that you have accepted all the changes and you've resaved it and gotten rid of everything, sometimes it doesn't work. And depending on the settings of the receiving person's computer, it may come up showing all of the changes that were made to this document. Now, usually, I mean, if the comment's something like, no, there's no comma that should go here, or I've told you 8 times before, this is how you spell the client's name, or something like that, it's not a big deal. But what if your comment says, well, our client will pay $500,000, but he doesn't want to start there. That's very detrimental to your case and your client. And there have actually been instances of things like that. So I discourage the use of the comments. Yes?
I assume if I make a copy PDF and attach it, that the metadata.
Some metadata will appear unless you use PDF, the full Acrobat suite. I haven't used Reader for a long time for this, so I don't know if it still does. But I think the tab is sanitized, and so after you create a PDF, you can go back to into the document and take out all the metadata. So they can't, I mean, the metadata that's going to come out of the PDF is probably not going to be useful, but better safe than sorry. And it only takes 2 clicks to scrub the document before you send it out as a PDF. Where the comments become troublesome is, because I do litigation, that's more, you know, I'm not writing contracts a lot, but if you're working on like a pretrial order and going back and forth, and you're using the Word version, or some of the judges require Word versions now of, I've had them require findings of fact in Word, pretrial brief, so that if they want to, they can then just take material out of what you wrote. And you certainly don't want a comment popping up on the judge's screen saying something like, well, make this simple enough for our idiot judge to find it.
What is that called?
And I forgot to restate your question. For those on the webcast, the question was, is it okay to send a PDF of a Word document? Does it still have anything in it? The command in PDF or in Adobe, you go to Tools, and then there's a box that will say Sanitize. And then you click on that, and it will ask you what all you want to remove. There's like 2 levels of removing stuff. And you select, just select the highest one and get rid of everything. Now, one thing you cannot do, and I didn't actually know this existed, you cannot use a web bug to track emails or that you send to other people. There apparently are electronic bugs that you can attach to emails that will identify the computer that opened it, the email address of who opened it, how long they looked at it, whether it was forwarded, and the ethics committees that have looked at that say that that constitutes engaging in misrepresentation and deceit. Now, going back to electronic data, committees have been finding regularly that you have a duty to implement sufficient security and training protocols to prevent electronic data breaches. So you need firewalls, you need security software, and you need to train your staff. This is what I was talking about earlier. Some recent ransomware, malware has been aimed at attorneys. So watch for those new client requests for representation that only comes in by email. They come up with reasons why they can never call you, you know, time zone, whatever. And if you are breached, you have a requirement to notify your clients of the breach and the potential loss of confidentiality. Now, there are cyber insurance policies that you can buy that will insure you from various events, such as malware or breach of confidentiality, and help you, because if you have a breach, it's going to cost a lot of money to get your system fixed. So these insurance policies will help you get your system back up and running. Another card. So monitoring of email is bad. But one of the things that we run into a lot is clients send us email from their work address. And that work email address belongs to their employer. So if the employer, if the employee is fired, or the employer is bought by another employer, and there is important information in the emails that your client has been sending you, that is very problematic, because the company can just say, you know, we're wiping it. We have no responsibility to you. We actually have it in our engagement letter that says, do not communicate with us using your work email. And most of our clients, I mean, you know, if the guy is the business, He's self-employed, that's not an issue. But when you have clients that work for big companies, that is an issue, and you need to protect against it, because things can go very wrong if there was important stuff that was lost. And most employers have policies that anything on their computers is the employer's property and may negate privilege. We actually have kind of an ongoing issue. We have a suit against a big insurance company that bought a smaller insurance company. And there's some earn-out, future earn-outs. Some of the people who have an interest to be paid off from their ownership in the small insurance company still work for the big insurance company. And a couple of them requested that we send litigation updates to the big company's email for that person. And a couple of people were highly offended that we said, no, if you want to read about what we're going to do in the litigation, you need to give us another address. We'll mail it, we'll use another email address, we'll do whatever, but we're not sending it to your company email. The ABA in May of 17 issued a new opinion that requires an attorney to use reasonable efforts to make sure that communications with clients are secure and there's no data breach. And they consider that one of the elements of competence. Along with that, however, if highly sensitive information is being sent, you may have a duty to use a higher level of protection. In our office, we have a subscription to a thing called Sherrets. And it's useful. Mostly we use it for sending huge amounts of files that you could never get into a normal email. But it also has an encryption function. And all you have to do is load the material into the email, click encrypt, and send it. And you've taken that extra step to protect that highly confidential information. Now, defending yourself on social media. Here's some things you can't do. You cannot disclose confidential information. The response may not injure the former client with reference to the prior litigation. I would hate to read that as saying it's fine if it causes them injury in something unrelated to the representation. The attorney should not say more than necessary to rebut the allegations. And at least one bar association recommends that before any response, you consider if a response is going to bring more attention to it. And you're going to know your client. There are some people that might just vent once and then they're going to go away. There are some people that if you respond, that may just generate the whole chain of things. So before you make any response, really think about it. I actually had a client hire us once just to write a letter to a person who was making derogatory posts about their business. But after we got the letter written, he said, let's just hold on to it, because I'm afraid if we send it to her, then she's just going to expand. And sure enough, she got bored after a while. And we had another instance, a different client asked me to send a letter. Someone was making late night posts very specifically about this company and some of its management employees. And we sent him a letter, and he actually called up and apologized. So it kind of depends on who is making the posts. Now, if you do reveal confidential or privileged information defending yourself against internet reviews, you likely will be subject to discipline. Lawyers so far have been disciplined for this in Washington, D.C., Illinois, Georgia, Wisconsin, and Oregon. Before you make any response, read it a lot of times. Preferably have somebody else read it also. Some examples of what people have done that got in trouble. In the Washington, D.C. case, the attorney revealed confidences in defending herself against an ABO review, and then she posted information about the results of the bar grievance that was filed arising out of this particular incident. and she received an informal admonishment. In Illinois, an attorney was retained to represent an individual in getting unemployment benefits. And the attorney responded on ABO. And here's the response. The person did not reveal all the facts of his situation up front in our first and second meeting. When I received his personnel file, I discussed the contents of it with him and informed him that he would likely lose unless the employer chose not to contest the unemployment. Employers sometimes do this. Despite knowing that he would lose, he chose to go forward with a hearing to try and obtain benefits. I dislike it very much when my clients lose, but I cannot invent positive facts for clients when they are not there. I feel badly for him, but his own actions in beating up a female coworker are what caused the consequences he is now so upset about. Well, that didn't go well. Although the opinion suggested that if she would have stopped after I felt badly for him, there would not have been a problem. But her revealing the basis for his going to her of the engagement, the facts of the engagement, she received an informal admonishment. And this is what the restatement third has to say about it. According to the restatement, a lawyer may act in self-defense only to defend against charges that imminently threaten the lawyer or the lawyer's associate or agent with serious consequences, including criminal charges, claims of legal malpractice, and other civil actions such as suits to recover overpayment of fees, complaints in disciplinary proceedings, and the threat of disqualification. Imminent threat arises not only upon filing of such charges, but also upon the manifestation of intent to initiate such proceedings by persons in an apparent position to do so, such as a prosecutor or an aggrieved potential litigant. However, generally a post on a website, absent prior unrelated waiver of confidentiality, is not the kind of proceeding that allows you to use confidential information to defend yourself against an online post. However, if the statements go beyond mere opinion, you may be able to sue the person. And now this is one of the times when it's positive that once it's on social media, it never goes away. Because if you need to defend yourself and say, this is what they posted, you're going to be able to find it. In the case where the attorney recovered, the former client made very detailed allegations against an attorney in online posts. In upholding the damages awarded to that attorney in a suit for libel and finding the post went beyond expressions of opinion, the court said, all the reviews contained allegations that, whatever his name was, lied to the client regarding the attorney's fees. 2 of the reviews contained the allegation that the attorney falsified a contract. These are factual allegations, and the evidence showed they were false. On the other side of the coin, however, if what the client posts is just opinion, then you're not going to prevail because they are allowed to give their opinion. We talked a little bit about what constitutes a controversy. It's not just having a negative review. However, I found this was interesting, that a former criminal client being interviewed for a book said that the attorney committed malpractice. And they found that that was a controversy sufficient to release the attorney from the duty of confidentiality in order to defend himself. I speculate that this might have been motivated by the fact that if the attorney had not been excused from the duty of confidentiality, the book would have contained accusations of malpractice that could have severely damaged the attorney. But again, a negative client review is not enough. So if you're going to respond, do not reveal confidential information. And just as kind of an aside, if they are going to post negative reviews, the odds are they're also going to make a bar complaint. Do not forget that bar complaints are confidential. So a post such as, well, he said the same thing to the bar and they said I didn't do anything wrong, could get you in trouble because that's supposed to be confidential. A terminating representation. Can you withdraw from representation of a client because of their publication of confidential matters on social media? Yes, if your agreement says so. This is what is included in our engagement letter. As part of this agreement, you agree that you will not publish anything referring to or relating to this case, any persons involved or in any way related to this dispute, or the underlying facts on social media, including but not limited to Facebook, Twitter, MySpace, or a blog. If information relating to this case is found on social media, the firm may choose to terminate its representation in this matter. You further agree that you will not provide information to any other person for publication on social media. In addition, if you are contacted by any newspaper, television station, or other outside entity, you agree you will direct them to contact this office before you speak with them. There is nothing worse than picking up the morning paper and seeing an interview with your client in which they make all sorts of untrue facts. There's a second reason for this too, in addition to cautioning your client. Some bar associations have gone so far as to say that the attorney's responsibility of competence and diligence includes the duty to review what their client is posting on Facebook. I don't want to be looking at everything that my clients are posting on Facebook. I don't want to be their Facebook friend. I don't want to do that. So I'm glad that we have this in the agreement just saying, hey, don't do it. So we're taking precautions to try and keep anything from getting out there on the assumption that they're going to follow the terms of the contract. I'm going to take the position that we do not have to review their Facebook posts. A lot of the places where attorneys get in trouble with their clients posting things involve domestic cases, because you probably know how clients in domestic cases behave. And getting them to restrain themselves on Facebook, especially if they think they have a sympathetic audience, is very, very difficult. But we've included this in our fee agreement for probably 5 years. And fortunately, we didn't have a bad experience. But I went to a seminar sponsored by the bar in which they explained all the instances in which a client had totally sabotaged his or her own case by their client posting on Facebook. Fairness to opposing party and counsel. You are not allowed to ask a third party to friend someone in order to gain access to non-public information. You may not create a different or misleading account to mask your identity. And what social media postings must be produced in response to discovery? Now, starting with the bottom one, what needs to be produced, I would consider that the same thing as in regular discovery. Does it come under the request? If the request would encompass the subject of these social media posts, then you have the obligation to produce it. Trial publicity. This one kind of surprised me when I was looking into it, because we all know that what we say in the courtroom has a privilege, if not absolute, at least qualified. with the proliferation of social media and the ease of access, courts are beginning to find that if you use social media or even traditional media outlets to publicize a suit, you may waive the litigation privilege for matters stated in a legal proceeding. And multiple courts have found that just sending a pleading to the press or posting it on your website waives the litigation privilege that otherwise attaches to material and pleadings. This does not hold true, however, if the media finds it. So if the media digs it out, if it's their day that they went to the U.S. District Courthouse and you just happen to file your case that day and they find it noteworthy, then they're publishing it on their own as a matter of interest to the public it will not waive the privilege. But you're reaching out and putting this information into the public without, there's kind of a qualification that, if it's not of public interest, but most of us think that what we're doing is of great public interest. So it would be very easy to, publicize what you're doing. And if you do that, you run the risk of being liable if there is anything defamatory or otherwise harmful to this person who's the subject of the complaint. Now going back to asking, not asking someone to friend someone, this was in New Jersey, and a team of attorneys asked, well, they had been following the client, the opposing party, on Facebook. But finally, either they talked to their attorney or somebody, and they changed their Facebook settings to friends only. So they asked the paralegal in the law firm to send out a friend request, and the guy accepted it. So they then began following him. The court found out about this when the attorneys added the paralegal to the witness list and said that she was going to be testifying about the social media posts. Now, as an example of kind of how inconsistent things are in this area, a regional disciplinary committee found the attorneys who asked the paralegal to friend this person had not done anything wrong. However, the attorney discipline office in New Jersey believed that they had done something wrong. The opinion didn't actually get around to saying whether they had or not. It was mostly devoted to the jurisdictional issue of could New Jersey step in after the regional board said that there was no discipline. But commentators who've written on this case seem to be of the opinion that the regional committee got it wrong, because one of the prescriptions is against going outside of the public information to try and find out about your client. Think of it as, it's the same thing as you would probably not be allowed to call up the opposing client's neighbor and ask them questions about that person. That crosses the line. So does finding a way into their private Facebook account or other social media or email. So do not hire a hacker. And this is that case. And also, just a note here, I think that they have dialed it down, but Facebook has an algorithm that if you have a bunch of people as friends who are also the friends of some other person that you may never have heard of, Facebook sends them a friend request for you. As I have, I think, about 3 Facebook friends who accepted a friend request that I did not send. Fortunately, one's like an actor and one's a photographer, stuff like that. So no harm, no foul, I guess. But you need to tell your clients to watch that very carefully. And if they get an alert that somebody just accepted their friend request that they didn't send, they should chase that down and try and find out, who it is and make sure it's not somebody who's trying to get some more information related to the litigation or to the family situation or whatever. Communications concerning a lawyer's services and advertising and contact with prospective clients. This is another area where a lot of attorneys get it wrong. Okay, can you use paid lawyer referral services? A big maybe. In Nebraska, there is an opinion that says you may use a nonprofit referral service. North Carolina explicitly allows the use of AVO and similar services. However, as of June 2017, Ohio, South Carolina, Pennsylvania, and New Jersey have explicitly found that use of AVO is not permissible. So that's going to, that's something that's going to have to be decided by every state. And I couldn't find anywhere where Nebraska has delved into that. Now, the areas where the states who have barred attorneys from using AVO, AVO does have billing that if you accept a client from them, then they take payment for that. That's been considered fee splitting. Now, AVO has since, they've been restructuring the way that they pay so that you pay a monthly subscription and AVO gives access to the web to people looking for your information. The problem with that is AVO then ranks attorneys. They compile, who knows what kind of an algorithm they use, but they take things into consideration like how long the attorneys practiced, what their practice area is, and then they give them a rating. The states in which they found that AVO is impermissible have looked at that and said, okay, this is impermissible because what the attorney is really doing is the attorney is paying for a recommendation. And we are not allowed to pay for a recommendation. Now, what is advertising? According to the California bar, a blog included in a law firm's website is a communication subject to the rules and regulations on advertising. I will say, though, that California has its own whole separate bunch of rules. So they have specific rules that are different from everyone else. In Nebraska, you can advertise on a website that provides information about Social Security benefits. So it would be my interpretation that the same reasoning would apply, that if what you do is related to some other field that somebody might be looking for, that you would be allowed to have a link to your services on a website that advertises that area. Now, a standalone blog by an attorney discussing legal or other issues is not a communication subject to the rules and regulations about advertising unless the blog directly or implicitly expresses the attorney's availability for professional employment. So if you have a blog and you're writing about, if you regularly write about things other than legal representation, and you never say, gee, this is the kind of situation I could help you out in, or something like that, then that's probably not advertising, and you're good. But if you go that next step and you say, if you're interested in learning more about this, if you're interested in learning more about how this law would affect your life, if you're interested in more information about changing your child custody arrangement or anything like that, that's going to be advertising subject to all the rules. Any electronic posting for the purpose of advertising by electronic media is subject to the rules and regulations about advertising. And the New York Bar Association has a rule prohibiting solicitation through live computer access communications. And that includes instant messages through social media and communications transmitted through chat rooms and on blog posts. And it's also a really, really good idea because things like Snapchat, they erase the message. So it would be my strong recommendation that you never use Snapchat to give anybody any legal advice. Because if they later say, well, but you sent me this Snapchat and it said this, there's no way that you can go back and find that to say really what your advice was. Although my experience has been that Snapchat is the favorite of a lot of people still in high school and college. Those of us who are beyond that don't use that so much. Although when I was researching this, I did find a comment by one commentator who said that convincing attorneys of a certain age or above that Facebook is rampant may be difficult. I'm well beyond that mark, and I'm still deciding whether I should be insulted or pleased that I'm an exception, because I am on Facebook a lot. However, one of my personal restrictions that I've made for myself, I only have 2 attorneys who are Facebook friends. I have attorneys who are real friends, but you never know who they're linked up with. And just as an example, one of my 2 attorney friends is Facebook friends with an attorney who's on the other side of the case I've got right now. The attorney, who's a very good attorney from Lincoln, was on vacation in Bermuda. And the prescribed attire is the blue sport coat and Bermuda shorts. So he posted a picture of himself in Bermuda shorts on the island. My friend liked it or commented on it. So I got the picture of him in the Bermuda shorts and the jacket. And now I just keep seeing him, wearing shorts on the beach instead of, being the attorney on the other side. But, and I have also received posts that somebody else liked from attorneys that I would be afraid to make. For example, commenting on the judges in a particular county, or how long it takes to get rulings from a particular judge. Because you never know, unless you have your settings at the very highest level where only friends can see them, no one can forward them, you're at a risk of anything you say being sent on. And I've discovered that even if somebody has only friends or it's a closed group that you belong to, you can copy posts sometimes, and then you save it to your phone, and then you can repost it. So the privacy settings do not really save you or your client from anything that you put out there being spread to wherever. Yes? The question was an expressed concern over listservs that maybe the opposing counsel would be reading the listserv. That's a really interesting question, and I never, I'm not on the NATA listserv, for example, but I am on the probate real estate section. But the questions that come up on them tend to be very collaborative. For example, I posted a question the other day. I do not do estate planning, but people from church ask me questions. So I posted the question. It was about Medicaid income limits for when you're in a nursing home. And I'm totally clueless. So I just posted that question, and I got several responses. Also, I had a question because it's been more than 20 years since I had to get a settlement with a minor approved by the county court. So I asked a question about that on the probate listserv, and I got awesome responses. They pointed me right to a code section that's new since the last time I did that, and actually allows us to not get it approved because the minor in this case is 18. So that's going to make finalizing that settlement a lot easier. So I find it very, very useful, but boy, I would agree that if it's going to be anything too specific or like a very identifiable situation, that you not put it on the listserv. That you just send it out to people that maybe you confer with regularly. There are two attorneys that we kind of have a little circle of answering questions for each other because we specialize in sort of different areas. And you can also, if you're interested in this, on Facebook, you can create what's called a closed group. And so nobody can come in without the permission of the administrator. So you could do it, your firm could have one, you could have it with just a certain number of attorneys, maybe from a different organization, something like that. For example, I belong to our block has a Facebook page so that we all know what's going on because it's a very, very long block. I belong to a rescue group for bassets and beagles. So if anybody's looking for one, I can hook you up. But you can use that, and it's very, especially the block Facebook page, we find out about, you know, if the street is closed because of a wreck. So it's very good to have the instant transfer. And with those, nobody can come in unless the administrator okays them. Okay, these are all posts by an attorney in California. First one, case finally over, unanimous verdict, celebrating tonight. I'm very jealous of that one. I just published an article on wage and hour breaks. Let me know if you would like a copy. Won another personal injury case. Call me for a free consultation. Another great victory in court today. My client is delighted. Who wants to be next? And finally, won $1 million verdict. Tell your friends to check out my website. Well, someone disapproved of his post and turned him into the Bar Association. And this is what the Bar Association in California found. The only one that they found was not a communication subject to the rules and regulations was the first one. Case finally over, unanimous verdict, celebrating tonight. On the second communication, another great victory in court today. The problem that they had with that one was my client is delighted because California explicitly prohibits client endorsements. Nebraska does not. However, in Nebraska, you have to make very certain that you have the person's permission to use them for an endorsement and that the endorsement is not misleading or doesn't say something that cannot be verified. And the who wants to be next. That's an obvious solicitation. Now on these two, I do not, I don't understand the reasoning on these two. But on the one another personal injury case, call me for a free consultation, I don't find it that different from won $1 million verdict, tell your friends to check out my website. However, the one that said call me for a free consultation, the bar found was an unsolicited advertisement because it offered services to people who the attorney had no reason to know might need his services. And then the final one, won $1 million verdict, tell your friends to check out my website. That one was also found to be a solicitation. But the just published article on wage and hour breaks, let me know if you would like a copy, they found that was not a solicitation because it would take a person would have to have an independent interest and take an independent action to contact you about that specific information. So I guess the rule on this one would be do not count on any particular disciplinary committee finding any particular way on communications. I just want to give kind of a comment here. Most of the information in here is from civil litigation. If you do criminal litigation, there are probably other things that you need to be concerned about. And I also have a couple of examples of prosecutors gone wrong that we'll be talking about later. But it's not just attorneys who have run into trouble on social media. According to a Keith Swisher, who is an Arizona attorney specializing in ethics, he says, unlike other social media users, judges are properly subject to unique restrictions and disqualification issues relating to the content of their postings and their online connections. These restrictions are justified, in part, to assure parties of judges' impartiality, both in actuality and appearance. So some examples of where judges have not got that right. A part-time magistrate judge in Florida resigned after posting remarks on Facebook about snowflake counter-protesters and nutcases who tear down Confederate statues. A Texas judge may face disciplinary proceedings for responding to a friend's Facebook post about being sick. I've had the worst cold, but instead of staying home, I'm being tortured by an attorney in a trial. So I'm actually jealous of you. Sorry. They found that that one showed disrespect for the judicial function. A New Mexico judge was brought before the New Mexico Supreme Court to determine if his posts on election Facebook page about his role in the case and his opinion of the result violated judicial ethics. And this is one of my favorites. A California judge was publicly admonished where he posted about a candidate opposing one of his colleagues, stating, "She has sex with defense lawyers while she is DA on his cases and nobody cares." Interesting politics. Now, even though the judge was admonished, his post was responding to a post the previous year when that judge was up for election from the DA who was being accused of sleeping with her clients, saying, "The judge uses his office for sex and yet many aren't concerned. Crazy politics." And the judge had been censored for having sex with his law clerks. So, kind of, I guess, if you live in a glass house, do not throw stones. Now, another judge was found to have detracted from the dignity of the judiciary and the court system by posting tweets containing an excerpt from an examination in which the defendant used profanity toward the judge and recounting an instance in which a defendant threw bottles of urine and feces at a judge following sentencing. I'm completely baffled by this. I mean, it was a factual incident. It was certainly not the judge who was dissatisfied or, impugning the dignity of the judiciary. If people behave like this, I don't think it's incumbent upon the judge to have to keep it secret. I mean, maybe they didn't want to encourage it by other people, but I can't imagine that very many people would find that encouraging advice or a good idea. And this is kind of an interesting one because this one's all over the place. Just recently, in the last 3 weeks, Florida Supreme Court found that being Facebook friends with a judge does not necessarily constitute a friendship significant enough to require a recusal of a judge presiding over a trial in which the friend attorney was counsel. Now, in this case, there were no communications between the judge and the attorney. There was just the fact that they were Facebook friends. And I think, if I recall correctly, they stumbled on it when the attorney on the opposing side received a friend request from somebody and saw that this person was friends with the judge. However, let's go back one. Florida also, before this case where they said a friend didn't necessarily require disqualification, Florida said that judges cannot be Facebook friends with attorneys. And that's a case from 2012. And they said if you were friends with an attorney, that would require disqualification. Although this case involved a prosecutor. And they based this on an ethics committee opinion, but the committee was widely split. So prior to 3 weeks ago, in Florida, there was a blanket prohibition on judges and attorneys being Facebook friends. South Carolina says judges can be Facebook friends with attorneys as long as no case-related matters are discussed. However, there are cases in which the judge and the attorney actually had discussions about the case on Facebook, which I have to say is one of those where you think, who would possibly do this? And in that case, it was required that the judge recuse himself and the attorney was disciplined. The Alabama Supreme Court is currently looking at a case deciding whether a Facebook post by a black judge 18 months ago should prevent him from presiding over a murder trial in which a white police officer is accused of killing a black man. And the judge had posted that he was walking around his neighborhood carrying a stick and he was accosted by the police. And when he asked why they were investigating him or why they were talking to him, they said, well, we're looking for a suspect who has a crowbar. And so the judge remarked that he could see no resemblance whatsoever between a stick and a crowbar, and then informed them that he was a judge. He recounted this story on Facebook, and I'm not sure how the defense attorneys in this case got a hold of it, but they are challenging him presiding over that case. The judge refused to recuse himself, and his reasoning was, look, this is a murder case. That was just, a post about what happened. The police officer in that incident was black. And then he said, I can take off this black robe, but I can't take off my black skin. You're the one who injected race into this. I'm going to be interested to see what the Alabama Supreme Court decides. But it's a very interesting interplay between, the judge's private life and being on the bench. Because 30 years ago, the judge could have written, an article about it or something, and still people would not have seen it. But if you put something on Facebook, count on it going somewhere else. Now, a judge in Texas was reprimanded and ordered to complete racial sensitivity training and 30 hours of training for new judges following a Facebook post he made after the arrest of a black man for killing a white police detective. The judge recommended, quote, a tree and a rope, unquote, for the defendant. When he was called out on this, he attempted to defend himself by saying that, well, he was talking about hangings in the Old West, like the old Pace picante sauce ad, that when they learned that the picante sauce was made in New York, somebody says, get a rope. But that argument did not get him very far. Misconduct. This is a whole other world for opportunities to mess up. Electronic as well as personal contact with jurors is prohibited. However, you can use social media to investigate jurors as long as it's a site that does not send a notification to the juror. For example, I don't know how many of you are on LinkedIn. LinkedIn, if somebody looks at your profile, they send you a notice and says, your profile was viewed 3 times this month. And then it says who's looking. And you can click on that, and because I don't have the paid level, it will just say a person with the title such and so at such and such a company. It doesn't tell me who it is. If I had the paid subscription to LinkedIn, it would tell me who was viewing my profile. So LinkedIn is probably not the one to use to investigate the jurors. Conduct prejudicial to the administration of justice may arise through impassioned tweets or emails, and we're going to get to a wonderful example of that in a minute. It is not permissible to publish information about a case in an attempt to flip the public scales in favor of your client. Some attorneys, especially those who have blogs, have very large followings. This is more common in very metropolitan areas. If you post something about a case that you are working on, you need to make sure that it falls within here the Nebraska guidelines for what you can say about a case. If you could not say it while you're being interviewed by a reporter with a microphone in your face, or a newspaper reporter is taking notes, if you should not say it there, do not post it on Facebook. And an attorney is not allowed to attempt to access the private portion of any social media of a judge presiding over a case the attorney is involved in. An attorney may not attempt to access the private portion of any social media of any jurors. You may not attempt to access the private portion of opposing counsel's social media. And text, tweets, and Facebook messages may constitute ex parte communications with the court if they even vaguely reference an ongoing action. Some cases where they found that the judge had to be recused was like the example I gave you, where the one counsel was actually chatting with the judge in the evening about what had occurred in the courtroom. The opinion didn't elaborate on whether it was things like some ruling that the judge made, or whether it was more like, did you notice at 3 o'clock that juror number 8 went to sleep? It didn't make that distinction. But I would be very, 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 very cautious about having any electronic communications with a judge, no matter how innocuous, while a trial is going on. Now, a Louisiana attorney, and I'm going to show you her message in a minute, a Louisiana attorney was disbarred for using Twitter and an online petition urging people to contact 2 judges who she alleged were unwilling to entertain evidence of child abuse. The attorney asked the public to make ex parte contact with the judges and the Louisiana Supreme Court to make comments about ongoing cases. And the posts that I have reproduced do not contain the phone numbers, but she included the phone numbers for the judges and the other people she was urging just the public to contact. Gimme, gimme, gimme evidence. Want some? I got it. Think you can convince a judge to look at it? Sign this petition. Judge Gambrell, names the judge, at it again, turned a 4-year-old child over to a validated abuser. Please tell me what it will take for everyone to say enough. And this is just an example. She apparently carried on this campaign for several weeks over this case that she was involved in, where she was representing one of the clients in a custody dispute. And that was sufficient for the Louisiana Supreme Court to disbar her. They said that her posts reflect a horrifying lack of respect for the dignity, impartiality, and authority of our courts and our judicial process as a whole. The lawyer then attempted to justify her actions on the basis of the First Amendment and freedom of speech. And Louisiana felt that was not appropriate, and they did disbar her. You know, a lot of these cases come out of the South. So I'm wondering if people down there are just lose their temper more quickly, or feel more casual, or whatever. Although there is a good case from North Dakota that we'll be getting to in a while. Okay, in Florida, the defense attorney was sanctioned after they sent, he aired these grievances on his personal blog, and the judge had asked if they were ready to go to trial just a week after arraignment. And the attorney remarked that the judge was an evil, unfair witch, that she was seemingly mentally ill, and, quote, clearly unfit for her position, unquote. The attorney was publicly reprimanded and fined. Now, if you are in the unhappy position of being a party to a domestic proceeding, just don't post anything anywhere. that's a big place where people go too far, because when your emotions are driving you, you're not thinking with the attorney side of your brain. Now, this guy must have been kind of a handful, because he had been a judge, and he, a woman that he knew, he actually granted a default judgment to and was disciplined for that. So he was removed from the bench. Then he was practicing law, and the woman that he'd granted the default divorce to that got him off the bench, he then represented her husband in a proceeding without getting her permission. But his real problems arose when, while on suspension, he decided to air his grievances with the natural father of his wife's child. He posted the following on his Facebook page. My stepdaughters have plenty of sunshine in their lives, except for the stupidity of their natural dads and stepmom. Another post. I realize as a matter of record that your hubby admits that he's no rocket scientist. You are either hilarious or completely lacking common sense. What a waste of human resources, times, energies, and finances. Another post. I don't want a psycho endangering my family. And there were dozens of similar entries. And this is the guy from North Dakota. The North Dakota Supreme Court found that the entries on Facebook constituted communications with a represented party because his wife and her ex-husband were involved in a custody dispute over the child, and were disparaging and demeaning. And although I was kind of surprised at this, because I don't do bankruptcy except for adversary proceedings, and people who do bankruptcy, the attorneys are generally pretty level-headed. But in Georgia, a bankruptcy attorney received a reprimand, and then the Georgia Supreme Court decided that was too lenient a punishment. And he was sending inappropriate emails to the opposing counsel in his divorce. The attorney said he, quote, admits that the emails included inappropriate threatening language, intimidation, and personal attacks directed to opposing counsel, including inappropriate remarks about counsel and members of her family and ad hominem statements about his wife. So, again, if you are a party in a domestic dispute, do not post anything. Just communicate in normal channels, talk on the phone, don't put anything in writing. Now, in Minnesota, and this is another attorney who's behaving like this while they're already on suspension. He had his suspension extended for a minimum of another 30 months after sending an email to a witness represented by another attorney telling the witness not to cooperate with the attorney investigative committee. And that's definitely one of those where I think, and who would think this is a good idea? In another interesting case, I was talking about Facebook groups a little while ago. In a criminal trial that was going on for a long time, 5 of the jurors formed their own Facebook group and were chatting on Facebook about their observations of the trial. One of them finally felt guilty and told the judge or the bailiff what was going on, and appropriately, they declared a mistrial. So the next trial that I do, I'm going to repeat the court's admonishment to the jury about not communicating via social media, because that's probably a lot harder nowadays when we're so attached to our phones than the prohibition against just talking to each other. Now, this is another one of those who would think this is okay. A federal judge found 2 lawyers in contempt for posting videos or links to videos on their website. And the reason was the federal judge had entered an injunction against publishing those videos in a civil case. These 2 attorneys, however, were representing the guy who secretly took those tapes and was being criminally prosecuted for secretly making those tapes. So they signed a confidentiality agreement, and still posted a link on their website allowing anyone to access the videos. That case is still ongoing. They have appealed the contempt, and the criminal proceeding continues. Now, this one is something that I think everybody should be aware of, because most of us who are attorneys are not web designers. And that means we have to depend on other people. In South Carolina, an attorney who retained commercial advisors for websites began using multiple websites with domain names including www.divorcelawyercolumbia.com and www.dmd-law.net. The disciplinary committee determined that the websites contained statements likely to mislead potential clients and contained unverified statements about the quality of the respondent's services. The attorney received a public reprimand. And the takeaway from that is, if you hire people to build you a website, you have to either watch them very carefully or provide them with the material that they're going to use. Do not let them write their own, because people who are in advertising are typically not as concerned with some of the ethical requirements of advertising that attorneys have to adhere to. In some of these cases, the attorneys have managed substantial misconduct. A recommendation was made that an attorney licensed in California be suspended after she said she could not produce computer metadata of time records supporting a multi-million-dollar fee request. She said that she used a wipe and delete program every day. The attorney was ordered to produce records substantiating her request for $24 million. It was a class action in, quote, native format. And what native format is, that's sort of in the format or the language that your computer understands when it translates to stuff that you can read. So she did produce paper copies and copies of her bills in Microsoft Word format. They hired an expert to examine the computer, which the attorney then refused to produce. The attorney was ultimately fined $165,000 and denied even a penny in legal fees. Although she was also fined for her initial request was for $24 million, but she misrepresented to the court that she had never asked for more than $12 million. So that kind of goes beyond social media. If you're going to be saying something to the judge, you probably don't want a contrary representation in writing somewhere, whether it's Facebook or in your pleadings. And even death may not insulate you from posts. Just in January, a judge in Los Angeles ordered an attorney to reveal the identity of his deceased client who had accused actor James Woods of being a cocaine addict. And the attorney had previously refused to produce that information, saying that he was, protecting the client's estate. But reaching back to law school, it's my vague recollection that the identity of your client is not a secret unless that's the reason that they retain you. So at least in California, you're going to be ordered to tell who your client was if they get in trouble for making a post. Now, prosecutors. Facebook can be an excellent place to find out information. For example, in one case, there was a 20-year-old charged with drunk driving, and the woman in the car that he hit was very, very seriously injured and was in the hospital for an extended time. He had pled that he was very sorry, was asking for leniency, and the sentencing was coming up. So the prosecutor went to his Facebook page, public Facebook page. Okay, that's the first thing to tell your clients, upgrade your privacy settings. But it pictured him partying at a Halloween party, dressed like a prisoner and visibly drunk. So the prosecutor brought that to sentencing, and he did not get a lenient sentence. And this is one of my personal favorites, in Florida, a prosecutor was disciplined after a mistrial was declared in a felony assault trial of a known gang member. The prosecutor had been posting updates on the trial to the tune of Gilligan's Island, although that might have been entertaining to see. Now, one thing, and it didn't make it into the slides, but one of the things that I came across was there have been some commentators and ethics experts who have suggested that it is a violation of your duty of diligence and competence to fail to use Facebook to investigate the facts of the case and to investigate jurors. That when you get the jury panel list, you should go on Facebook, use whatever public media there is. And that's kind of scary because it's not something, I mean, you know, I'm playing on Facebook all the time. I don't think it would have ever occurred to me that part of my obligation might be to use Facebook to investigate jurors or to investigate the situation. And as I mentioned earlier, if you are allowing your client to, if you know your client's on Facebook, you may have an obligation to look at that. Now, I talk really, really fast, so I kind of went through a lot of stuff very fast. Is there anything anybody would like to discuss or some questions? If not, I'll just keep talking. No questions? Okay. How many of you are on Facebook? Do you have your phone set on only friends, or do you have it on friends of friends? Just out of curiosity. How many has only friends? And if you don't know what that is, you can go into, I cannot tell you off the top of my head where, which setting it is, but you go into the privacy and it asks you who can see your posts. And you have the choice of public, friends, or friends of friends. And if you select friends, and a friend of yours tries to repost it or forward it to somebody, it will simply show up outside of your friends as attachment missing or something like that. But as I said earlier, there are ways around that that you can copy it. But that's kind of important because if you're going to be making public announcements, you need to know that you were talking to the public. We had a case that came in several years ago that was more advice than really ending up doing something, but it involved a young girl, and this story has now been made into a movie. So I'm not telling you anything that isn't already way public. A young girl was raped by high school athletes after becoming very, very, very drunk. Despite my telling them on a daily basis, both her mother and on behalf of the girl, to make her Facebook page private, she would not do that. She had a public Facebook page. So once the allegations hit the newspaper, and this was in one of those tiny towns. I grew up in a very small town where like high school football is really a big deal. Once her story got out into the community, the outpouring of hate and attacks to her actually resulted in her, not immediately, but she did not recover very well from the incident and made several attempts at suicide. So it's important for you to know how the privacy settings work so that you can both protect your clients and protect your own communications. And I was going back to, I wanted to talk a little bit more since I have so much time about metadata. I didn't focus on that here because metadata is not so much social media. But despite the ABA originally, talking about it's okay to search metadata, most of the cases that have come down recently that deal with metadata discovered in documents have determined that it is the responsibility of the sending attorney to scrub the data. that if you send something inadvertently to somebody and they learn something through metadata or through a comment in a Word document or something like that, you may have actually waived privilege, or you may have waived the confidentiality of that, because it is your responsibility to remove that data. And if you do not use Adobe Acrobat Pro, which has a very good sanitized program, I don't, because that's what I use, I don't know the names of other ones out there, but there are software programs that you can get just to scrub data from documents before you distribute them. And I don't know how many of you went to Creighton, but a few years ago, Dean Rafel was back visiting, and he was writing an article for the New York State Bar, which seems to be one of the ones that is the very most concerned with social media guidelines. They have a whole set of guidelines now for almost every element of social media. Although 28 states have specific technology rules, New York seems to be the one that has delved into it the deepest in more detail. So even though the New York rules are not identical with the Nebraska rules, if you're unsure of something, that would be a good place to check, because they've gone through and written very, very, very in detailed information about it. Now, I gave you a bibliography that were on the table out there. If you didn't pick one up, you should pick one up on your way out. Now, on the metadata, we recently had a case that was between two large companies and involving instances going back years and years and years. One of the issues that came up, and this is not so much social media, but it is technology, was the other side wanted to obtain the documents and take out the privileged ones before the documents were numbered. We, of course, wanted the documents numbered so that we could tell what were taken out. But there were so many documents that we actually had to hire a third firm to manage the documents. And they were managing all the documents, so we had to have them sign confidentiality agreements, and they were bound by that. But we did find out that there have been some remarks that people were, dealing with the management of the documents, not so much the content, but like complaining about the attorneys and how much work it was. So it's very interesting how quickly stuff will get out there. Yes. Oh, sure. The two cautions would be, don't use it to, for example, I post a lot of dog pictures. If you were posting dog pictures and saying, if you have an animal-related or a pet-related issue, come see me, and then as long as the stuff that you post on Facebook is stuff that you wouldn't care that anybody sees, then there should be no, or on the blog, then there should be no problem with it. But just as an example, I just recently got back from Washington State, where my daughter lives. And my daughter thought it would be really hysterically funny to take a picture of me in front of this very vibrant cannabis shop. And I knew if she did that, she would put it immediately on Facebook, which would then go to everybody. And I didn't think, for an attorney working in Nebraska, that standing outside of a cannabis shop was really the kind of thing that I wanted to be circulated attached to my profile. She's also done that, unfortunately, with my wedding picture from decades ago. It's pretty hysterical. The other question? Yeah, the question was, the first question was, the person had both a personal blog and a public, a blog for their firm, and asked if as long as they kept them separate, they were fine. And yes, unless, as I said, something that you just wouldn't want other people to see. But on the, I'm sorry, would you repeat the question again? You know, I don't think so, because that would be, you are not publishing anything, you are not harming the client, you're not violating confidentiality, you're not invading the privacy or learning information about opposing client or counsel. My only thought would be, if you do subscribe to that service and if it is effective and you have a very, very vengeful client, if their posts are getting deleted, I would guess that there are some people that would motivate to then go out and post as many reviews as they could on other sites. You know, I've heard about sites that do that, but I have not read anything about their efficiency. Now, another thing to kind of watch out about social media, and this is a scam that makes a lot of money. Somebody that I know, since I don't do criminal law, didn't come up, but somebody that I know a few years ago was arrested for a DUI. There is a company that goes into public records and takes all mugshots, and they then post them online with your personal information, and if you want them to remove it, you have to pay them like $100. And this was a person who was an immigrant, and so she was going to have a citizenship background check at some point. So, you know, she paid the money, because if you put her name into Google, that's the very first article that would come up. So there are a lot of ways that people can use social media to make money that we might not think of. Are there any more online questions? I would say no. The ones we've got don't usually show that easily that they're to a mass of attorneys, but they say very close to the same thing. Something like, did your firm handle contract law? I have a dispute worth this huge dollar amount that I'd like to hire you for. I generally, however, respond by saying, we do not accept any engagements unless we can talk to you by telephone. And then they usually go away. One thing though, and this is, there are so many scams still going around, and this is just my own personal entertainment. When I get those, like the Nigerian prince scam or whatever on my home computer, they have to have a valid contact in there or the scam doesn't work. Because if you can't get a hold of them, they can't convince you to send them money. So every time I get one, I respond by saying, thank you very much. I am not interested, but I appreciate your communication, because I will now forward it to the FBI, Department of Homeland Security, you know, whoever else I can think of off the top of my head, because that forces them to remove that contact information. Because if you do report it, then the authorities could find them and they could shut them down, because that's a viable means of contacting them. So it's just kind of a way of short-circuiting them before they get anybody who might actually believe the scam. Their contact will be gone. Any more questions? Yes. Yes. Some attorneys have, let's say that you know opposing counsel, or you know the client on the other side has a special interest. So let's just go with birds or dogs or something like that. So you create a Facebook page that makes it appear that you are somebody who is interested in, you know, dogs or birds or whatever, and then from that platform you send like a friend request or you send them an email saying, you know, subscribe to my feed or my blog because I say all these great things about, you know, dogs or whatever, and that's your way into their private information. By doing that, you have engaged in misrepresentation and deceit because you're saying, hey, I'm this person who's just this, when really you're an attorney looking for information. Now, that doesn't mean you couldn't have, you can have as many Facebook pages as you want for whatever interests you want, as long as the purpose is not to get information about somebody or from somebody who does not know that you are an attorney. You know, I looked in Nebraska, and except for the recent opinion, I did not find a lot of opinions or cases dealing with, you know, with social media yet. So it's very hard to predict what will happen. So that's where the caution really comes in. Be very, very careful, because in our state, we don't yet have a lot of ethics opinions out on it. Although the one that came out this week or last week, did anybody see the one about Bitcoins? I have to admit, and maybe it's because it's a finance thing and I'm not a finance person, the idea of Bitcoins still confuses me. But the bar opinion from Nebraska, the question was, can you accept Bitcoins as currency that you put into your trust account? And the answer was yes, but that once you receive it, you should probably convert it into actual currency or dollars as soon as possible, because, and this is my interpretation of Bitcoin, so it could totally be wrong, but their value fluctuates quite a bit. They're like being traded by people who are at a whole different level of internet usage than I am. And as a result, their value fluctuates a lot. So you would not want to keep Bitcoins in your trust account, because the value of them could fluctuate wildly from the date that you received them as being worth X dollars. But that opinion, I think that just came out, was either in August or earlier this month, and it's on, of course, the Nebraska Bar website. And we haven't had anybody suggesting payment in Bitcoins, and I was a little surprised about it, because there are a lot of other opportunities for messing up on the internet, and yet at least nobody has very much in Nebraska, other than the one who was not really handling the case and using email to kind of make responses to make it seem like he was working on the cases, to go right to Bitcoins. Because to me, that's very complicated. But the one thing about the internet is it is absolutely forever. And I would strongly recommend that everybody include in their engagement letter a prohibition about engaging in posting on the internet. Some of the things I have seen in other cases, a woman who was supposed to be on FMLA leave filmed herself dancing at a concert and posted it to her Facebook page. Well, her employer saw it and asked her to come in and talk about it. She refused. They fired her, and she sued them, saying, you violated the FMLA because I was on leave. And as long as, you know, my reason for leave was valid, then you can't fire me, even if I'm not spending every minute of my leave, you know, doing whatever. And the court said, I don't remember which court, they said, no, they can fire you. Social media has also been particularly devastating to plaintiffs in personal injury cases. Because sometimes, even if you're really injured, you have better days than others. And if you're doing something really fun, like let's say you are alleging some kind of permanent disability in your ability to get around, and you go to the zoo, Henry Dobley Zoo, and post a post, take a picture of some of the animals and say, I'm so exhausted walking around for 4 hours. If defense counsel gets that, that's going to be very, very, very damaging in front of a jury. And it's the kind of thing that would be perfect impeachment evidence. Also, clients really don't, I read a quote about this, but clients really, a lot of them don't, even though they're savvy about using Facebook, they really don't have any idea of the full scope of ramifications. They think there have been cases in which a mistrial has occurred because one of the parties to the case went online and began posting derogatory things about the judge. And even though it wasn't the judge's fault, the attorneys would argue that, once the judge has been insulted to this level, there is the appearance that he could not be impartial, because any human being who was having this stuff said about them would not be impartial. And, if you've worked up to a trial and you're halfway through a trial, that's a huge expense to go back and have to do over just because your client couldn't refrain from calling the judge an idiot or other more colorful things on the internet. And we also include the prohibition against, giving other people information to post, because there have also been cases where a family member or your best girlfriend or whoever, thinks you're getting a raw deal in your divorce. And so they decide to post on Facebook about what a raw deal you're getting and how, your attorney's an idiot, your husband's a criminal, he's done all this stuff. That's not only going to mess with your case if all that comes out, but it can also, create a situation where it makes you look bad for allowing this stuff to be published, because somebody could very well look at that and say, well, you allowed this to happen. Plus, people are really good about kind of thinking out of the box. So if you say you can't post anything, their brain first reaction might be, well, yeah, but my kid could, or my cousin, or best friend, whatever. So kind of limiting that in your engagement letter. And also, the literature I read did not elaborate on it, but think about the problem that you have when your client has just gone on Facebook and their view of the facts is maybe a little skewed, and they post all these facts that aren't true, or they post facts that they don't realize. Clients frequently don't understand the legal implication of the facts, so they post a bunch of facts on Facebook that really, really damages their case. But if you don't have that condition in your contract that if you post this, we can fire you, you are stuck with a client who has virtually no chance of prevailing if that comes into court. So if no one has any more questions, I'm going to end. We're about 5 minutes early. But, again, before you post anything, and think about it overnight. You might even, if you're responding to a client attack, you might even want to consider having somebody else read it. And sarcasm does not come across well on social media or in emails. So be very careful that your emails that you do send can be understood. Yes? That's a good question. I didn't read anything that talks about, if they're stupid enough, but it's kind of on the other foot, because the competence and diligence instructions are that you are supposed to know how to use it well enough that you should be investigating it. Yeah, well, that you should have told them not to, but it's the other attorney's kind of duty to dig it out. And that's what frequently happens. Well, thank you very much. I hope I gave you something useful.